Numbers 5 and 6 on the supplemental. People versus Jeremy Shu, 19-378 FH, 18-855 FH.
Jessica Blanche, appearing via people.
Good afternoon, Your Honor. Stuart Collis on behalf of Mr.
You can hold it, whatever you need to do.
Your Honor, may we approach?
Briefly, yes. All right. Today's the date and time set for arraignment on these violations. So, Mr. Shu, the only thing that you need to know is that you are being arraigned on violations of your probation. As far as the arraignment purpose is concerned, you just need to understand that if you were found guilty of the violations, you could be sentenced to the maximum for the underlying. So this goes back to what you were originally charged with, not necessarily just compounding probation violations. So it's possible that you could be sentenced to 10 years incarceration, because that would be count number 12 in that is the highest, I think, sentence that you were facing. So that's kind of where we are today, sir. You have the right to have a hearing. I'll hold on. You have the right to have a hearing. And at that hearing, Mr. Collis will represent you. You can call witnesses. You can question those witnesses. The prosecutor must prove by preponderance of the evidence that you did violate the terms of your probation. And so that is what happens at that hearing. And that is what is going to happen next week on October 19th at 1:30. I'll give you a brief question, Mr. Shu, but we're not taking a lot of time today to talk. You're on mute.
All I wanted to say, sir, is you told me at the October 3rd hearing that if for some reason TRICAP couldn't accommodate my medical issues, which I have, I'm going to back up so you can see. I'm currently
Mr. Shu, I am absolutely not going to listen to this. There is no question that TRICAP would have accommodated you yesterday.
They didn't have a walker or wheelchair, sir.
Okay. Well, we'll have to take that up next week at your violation of probation hearing, which will be at 1:30. You are remanded until that hearing. I will see you back here next week. Thank you.
Thank you very much, Your Honor.
Yep.
Numbers 24 and 25. People versus Jeremy Shu, 19-378 FH, 18-855 FH.
Jessica Blanche, appearing on behalf of people.
For the record, Your Honor, Stuart Collis on behalf of Mr. Shu. Mr. Shu, would you state your name for the record?
Shu, can you hear us?
Yes, sir.
All right. And we have Agent Benetti here, correct, also?
Yes, Your Honor, I'm here. Could we have a brief bench conference?
Sure.
Thank you.
I just want to see if any of my witnesses are on there by any chance.
I got a few phone numbers on there. Guest, street, they're all judicial people. Attorney Joe Hall, Attorney Nicole James. Nicole's iPad,
Yeah.
Trevon Jackson. People with phone numbers on there, they're supposed to put their names on.
Is there a number?
No, 9791.
What about
No, the rest of them are victim joy egg fits.
okay,
I was
where it was my mom or my girl like that.
Hey, Gibbs, press mute.
All right. We are back on the record in People versus Jeremy Daniel Shu, case number 18855 FH, 19378 FH. I believe also 19379 FH. Is that on the docket today too? All three?
Just two.
I think just two of those. So it's actually the 378 FH and the 855 FH. Record should reflect bench conference with probation, the prosecutor, and the defense attorney in this matter. The probation officer requested the bench conference to discuss the new allegations of violating probation with the incident. I'm just going to call it the incident that occurred at TRICAP, and how that was going to be kind of handled in terms of the prior pleas, as well as the technical violations, non-technical violations. I brought up, and so I'll put this on the record, that the defendant filed a pro per motion for reconsideration and immediate hearing on the motion. And so I was explaining to counsel, and I'll explain this to you, Mr. Shu, what I won't allow are our parties to pick and choose what they file versus what their lawyer files. So when someone has a lawyer, they've got to consult with their lawyer and come up with what is going to be filed on their behalf, unless and until they don't have a lawyer, in which case they can file their own stuff. And so what I explained to Mr. Collis off the record, and I'll explain it to you on the record now, is that you filed obviously an incredibly articulated motion. It was like 17 pages long, in terms of seeking reconsideration for your pleas on this matter. And if that's something that's appropriate for me to hear, I got to have Mr. Collis file that for you. So I'm not going to hear that. Plus, Ms. Blanche reported that she hadn't received a copy of that. So anything filed with the court has to be served to both the prosecutor and the defense attorney filing it. So, and the court. So I couldn't even consider it anyway if I didn't, even if I wanted to. So,
Your Honor, may I respond to that?
Sure, briefly.
All I wanted to say with that is I'm obviously incarcerated. I don't have the ability to put the mail in the mailbox. If Ms. Blanche says she didn't receive it, I don't know why she didn't receive it. I sent it out. If you look at the cert of service on that, I state that I sent it out. I believe that the mailbox rule applies, and I'm not trying to contest what the court is saying about Mr. Collis filing or not filing. I've spoke to Mr. Collis a couple times about filing stuff for me. Even yesterday when he decided to come up and see me at 8 o'clock at night about this case, I spoke to him about requesting material that he hasn't requested. I spoke to him about requesting witnesses that he hasn't requested. I also made contact with family members about retaining counsel, which is a very good possibility as of now. I don't know if they had an opportunity to get counsel retained. I would respectfully ask the court, depending on what the court intends to do today with the bench conference or whatever, if worst case scenario, if we can adjourn this so I can have the ability to at least try to obtain counsel that's going to be more effective for myself, because I haven't even had a 24-hour notice of this hearing.
Okay, well, I mean, that you've asked for what I'm willing to grant, because that was basically how I left the conference off the record, was that there seems to be some things that are not entirely resolved. So I saw your notice, your proof of service, but again, Ms. Blanche said she hasn't received it.
Okay.
So all I'm saying is that I can't proceed on your motion without your lawyer filing it, or if you don't have a lawyer, you can then file on your own behalf. And you've said to me that you're trying to get retained counsel, which is fine. So what I can do then is I can adjourn this 2 weeks to November 1st of 2022. But at that time, I think we're going to fish or cut bait. So I think that November 2nd, I'm sorry.
I was going to say, yeah.
But I think at that time, we're going to fish or cut bait, as they say, and we're going to have the violation of probation hearing. If in fact your lawyer, either Mr. Collis or retained counsel, files the motion for reconsideration or renotices that, we can have that on the record that day too, so we can take care of it at that time. If it's not filed by a lawyer though, or you still have a lawyer, I'm not going to consider that, and we're going to proceed with the hearing and we'll see what happens. In addition, if there are any other violations or anything else, those can be considered at that time. Okay?
Your Honor, may I say something briefly?
Yes, briefly, yes.
Okay,
Sure.
I completely apologize, sir. You
need to apologize. You're good.
You gave the opportunity of subpoenaing witnesses at the October 3rd hearing. You also directed me on the record to remind you that if I was terminated from the program based on medical issues, that this would be something that wouldn't be a violation. I specifically addressed the court about the medical issues and or legal issues, specifically law library.
Right, but I got to tell you, Mr. Shu, we're getting into stuff that isn't even been really, like, it's not on the table. So what I was referring to as the tri-cap issue, like, you're starting to speak now to maybe what happened there, and that's on the table as a violation right now. And we're not really at a position, we're not having that hearing right now.
I completely understand, Your Honor, and that wasn't the intent. You just directed me on the record on the 3rd, which the officer that was present at the court hearing is standing right here, to remind you of that. That's
the
really
officer is right there to remind me of that.
No, I said the officer that was present at court for the hearing is standing here.
Okay.
I said you directed me on record to remind you of that if you did not.
Right.
know. That was all.
Right. So I don't know, but I don't know the truth. We have had no evidence on what actually happened other than the alleged violation. So this is the whole thing about you're innocent until proven guilty. The standard of proof is preponderance of the evidence. There's no evidence before me. All I know is what's been alleged about you. So you're telling me kind of right now that you're reminding me about the medical issues. We are not even there yet. So I don't know what happened. I know what has been reported, what happened. That what has been reported doesn't sound medical to me or law library related, but I don't know the truth of any of this because I don't have anybody under oath telling me what happened. So we are a little premature in this. So
I understand.
I'm going to adjourn all of this to November 2nd at 1:30, and we'll take it
Your
all
Honor,
up at that time.
One
Yep.
issue before you do that. I know that in our bench conference, it was brought up that at least by probation, because I have not seen Mr. Shu's motion for reconsideration, that he filed it alleging essentially coercion and other things that I have allegedly done. I'm obviously not going to file a motion of that nature. I believe the plea was taken appropriately. I know that Mr. Shu also indicated yesterday that he wanted to fire me. I don't know what Your Honor wants to do with that, but it does raise an issue that I think needs to be addressed before that November 2 hearing.
Well, again, I'm not going to do an oral motion for you to withdraw, and I understand why you may feel that way, but we'll schedule that issue on the 2nd as well. Mr. Shu has indicated he may have retained counsel by then, so it could just be a substitution of counsel. So that would be fine. So Mr. Shu, if you hire a lawyer, your lawyer can prepare the paperwork to substitute for Mr. Collis, and you'll have a new lawyer. Okay.
One last thing, Your Honor, and I understand you're busy, and I apologize again, sir. If retained counsel does come in, once they're able to file the appearance, will they be able to have adequate opportunity to prepare? Or will it just
yes, in the sense adequate, Mr. Shu. They may, we certainly wouldn't adjourn this weeks and weeks out because it's a violation of probation.
I understand.
But I would certainly not make brand new counsel step in on their first day and do something. So we would be keeping this on a fairly prompt schedule. And I know that you're eager to resolve it too, because you're still in custody. So we're going to try to keep it moving as quickly as we can.
All right. I appreciate it, sir. Thank you.
All right.
Thank you
See you
very
back
much,
here
Your
on
Honor.
the 2nd. Yep.